Wait a minute. Wait, whoa, 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 whoa. He violated the no contact. He violated the judge's order. The judge told him, or the magistrate lawyer, whoever that is, told him on May the 10th, you're not going back to Matt's Drive. For whatever reason, he chose to ignore the judge's order. That's a problem. That's a big problem. And then I don't care what kind of help you intended to give the victim. When a judge says no contact, they're not kidding. He means no contact. And you had contact with him. It's not a violation of the no contact provision for the victim to have contact with the defendant, but it is for the defendant to have contact with the victim, at least as this order was framed by the judge. Where does your client work?
Let's go outside, Tom. Make sure it's coming.
Our file is on the last goes with, I'm gonna put that.
Okay.
Judge, you want to do the signing records for Judge Hudson?
Yeah, I'm going to do them, but I want to get these lawyers out of here first.
I'll put those.
Okay. Schneider National Carriers, to success, 118-143-B and A. Good morning, Mr. Scaly, your appearance.
Morning, Your Honor. Roger Cayley, P. 48811 on behalf of Schneider National Carriers.
So so there's agreed upon fines and costs on count one, overweight, $4,000, and then they're going to dismiss
Count two, that's correct.
count two, right?
That's correct, Judge. I have the
You're
authority to do that plea, plead responsible on my client's behalf.
I'll accept the plea, $4,000, and they can pay by June the 26th. Okay? Is
Yeah,
that
that's
good?
perfect. 30 days. June 26th, you said, Judge?
Yes, I did. Have a great day. Thanks, and I'm dismissing count two. Thank you.
Thank you.
All right.
Have a great day, Judge.
You too.
Bye-bye.
I know. Is there something, hey, Sadie? I don't know. There's something wrong with that. Let me get a chance. All right.
It's just,
Now I've got, pardon?
it was just off. Good.
Okay, thanks. All right, Eric Woods Johnson, 26B710716.
Sorry.
All right, good morning. We're gonna have to get the prosecutor in here. Where's the register of actions? Call the prosecutor in here, please. I'm gonna have to have them find the, I'm gonna have to have them find the register of actions. I don't know where it went. It's not in the file.
I mean, I'm having those listening.
Well, I'm talking about the register of actions for the file. You know, the cardboard type. Are you on Woods Johnson? Come on up here and tell me your name again, please.
People, P8652B.
Stucker?
Mayor, please, collect on top of there is 359229 representing Mr. Rich Johnson, that is my left.
Your name?
Eric Woods Johnson.
Somebody's misplaced the register of actions. It's not in the file. Can you check on that and I'll recall it momentarily? I don't know who,
No, I don't. I checked.
it's just,
Thank you.
Let me call this other case. People against Dennis James Ross Jr., 26X, 26M692118. Your name, you have to unmute. There you go. Your name, sir?
Dennis Ross.
I'm going to go ahead and dismiss your case. The officer failed to appear. I gave him 15 minutes. It was scheduled for 9:45. It's now 10:05. You are all set. Case dismissed. Slow down though, will you please?
Thank you, Your Honor.
Have a good day.
Bye-bye.
Thanks. Okay, there you go. Good, thanks. This is not the register of actions. They got to be careful back there. I'm talking about the register that we fill out everything. They've got the criminal history and complaint of violation of conditional bond release.
Looks like this.
Yeah, it looks like that. That's. Yeah,
They must have slipped out.
that's okay. We just got to be careful with that thing. All right, so I'm back on record and I'm Eric Woods Johnson, 26B710716. I'm gonna ask everybody to state their name again, please, for the record. Stand up, Mr. Woods Johnson. Tell me your name.
Eric Woods Johnson.
And Ms. Tucker Davis.
Mayor, please, the sound of court, Don Tucker Davis, P59, Don Woods Johnson.
Why don't you move over there, Mr. Woods Johnson? Ms. Alloway, your name? We have a potential bond violation. This is going to be a waiver, correct?
That is correct.
I'll take the waiver. We'll address bond before I sign the bind over certificate. Sir, you understand what your lawyer is telling me?
Yes, Judge.
Your lawyers, you have the right to a preliminary examination, but your lawyer's telling me that you're going to waive your right to an exam. There's two counts. Count one, felonious assault, a 4-year felony. Count two, domestic violence, for which you don't have the right to an exam because that's a 93-day misdemeanor. But on the felonious assault, you do have the right to a preliminary exam. And at that exam, the people would have to show that the crime was committed and that you were the one who probably committed the crime. By waiving your right to an exam, you will automatically be waiving that requirement. You will be bound over for further proceedings to the Wayne County Circuit Court. You understand that?
Yes, Your Honor.
And did you sign, read, and understand this document entitled bind over after preliminary exam / felony?
Yes, Your Honor.
Anybody force you to give up your right to an exam?
No,
You still have to do that.
yes, Your Honor.
Waivers accepted. I'm going to bind you over, but I'm not going to sign the bind over certificate just yet. But your court date will be on June the 9th in the Wayne County Circuit Court. Now, let's talk about the bond violation. There's a complaint of violation of conditional release that caused him, I don't know if they arrested him. Did they arrest him, Ms.
On the date of this incident or this case in question?
On the complaint of violation of conditional release?
No.
No. No.
So you need
That
to,
was sent in the last Tuesday morning to the court. If you recall, that was when myself and Ms. Tucker Davis received it.
And Mr. Wood.
did I address that already?
Yes, and so we set this court date for the hearing.
Well, complaint of violation of conditional release, and I'm not asking you to look at that. But when there's a complaint of violation of conditional release, it permits them to take him right into custody. In other words, if the police were called and by the victim and were told that there's a violation of the no contact provision, and they went out to the house because the defendant's still there, they can fill out this form and they can immediately take him into custody. That was not the case here. So the detective really needs to come and swear to an oath and explain what he has. And then the judge, whether it's me or Judge Hessen, are going to get to determine whether or not there's probable cause to believe that the defendant violated the bond condition, or at least by a preponderance of the evidence. So I'm not going to make an issue of it, but if this form, complaint of violation of conditional release, really should only be utilized when they're taking the defendant into custody because they have the basis to believe from their own eyes that he violated the bond. Otherwise, they should come in and do essentially a signing on record and swear under oath as to what happened. Okay? Am I making sense?
So if swearing under oath on the record is the alternative? If they did not take them into custody?
Correct. In this case, it appears to me she got the victim showed them text messages, right?
Correct.
So they wouldn't have seen him. So now they really should come in and what they could do it on record on Zoom. But they can't. It's fine the way he did it, but they're using the wrong form. They should be testifying in a case like this as opposed to filling out this complaint of violation of conditional release, which enables them to take the defendant into custody. That being said, I'm going to read it.
Your Honor, the complainant is here. I did, we're prepared to put her on the record. There have been other allegations that she has told me about that I would consider intimidation and harassment that I ended the court.
Is she in here now? Bring her in.
Would you like to begin a hearing then, or we call her in?
Yeah.
Okay, so you will call Agent Calvin. I will go. The advocate is here. I'll open up.
You guys can have a seat. Detective Vesprini, are you on this Bensick case?
Yes, Your Honor.
If you want to just bear with me a few minutes, okay? And I'll call it as soon as I'm done with this little hearing.
Okay, no worries.
All right, ma'am, come on up here. Whoever Ms. Calvin is. You can go right there to no, right behind you, right there. I'm just going to ask you to raise your stage.
With the microphone.
That's a
right
microphone.
Yep.
There you go. It doesn't look like one. I don't blame you not for not realizing it's one. Tell me your name if you would.
Asia Donovan.
All right, I'm going to ask you to raise your right hand. You solemnly swear right hand. Solemnly your right hand. That's your left hand.
Right.
It's okay. It's all right. I do that all the time. You solemnly swear or affirm the testimony you'll give in these proceedings will be the whole true self you got.
Yeah.
Don't be nervous. What kind of contact did Mr. Woods Johnson have with you on May the 15th?
He didn't have any contact with me. I returned back to the residence on Mother's Day. My father passed, and I left the residence in a hurry. I left all my stuff behind. And I returned on that day, and when I returned, he was in the home sleep.
Well, on May the 19th, I told him he may return to the property at 23652 Matt's Drive, Brownstown, after 6:30 p.m. I think you were still in there at the time. You don't own the residence, but he did this on May the 15th. Is that true?
Yeah, this is beforehand.
Well, counsel, how could this? Hang on one second. Let me check something. I did not do the initial arraignment. It was done out county, I believe. Was there a no contact provision?
Yes.
Yeah.
I was told that he wasn't going to return to the home, so that's why I left my things. I had packed them up. I had put them by the door. I had turned off all the lights, and I had left. It definitely looked like I was leaving. My things were packed when he got rid of them.
Okay, so May the 15th is the date that this occurred, that he came back to the residence? Is that true or false?
I'm not sure the actual day right now.
Your Honor, if you, I can show her,
I have the text message correspondence from when I had was in the house. I have audio from when I had came to the house prior to.
When were the text messages between the two of you?
It was the morning right after I had left.
So you gotta tell me, you gotta be more specific. I have to know dates. What date did you leave there?
Can I get my phone? So I can.
I think we have,
Yes, in my minutes.
You're the court would prefer, we could have it on the stand and, I could ask for.
That's fine. Have a seat over here, ma'am. You're still under oath. Go ahead, Ms. Oliver.
Could you please state your name for the record?
Angel Sweet.
So, Miss Calvin. Did something on May 8th bring you to court today? You have to say yes.
Oh, yes.
And, do you know somebody by the name of Eric West Johnson?
Yeah.
Do you see him in the courtroom today?
Yes.
Could you point to him and tell him the color of his shirt?
What?
Your Honor, please let the record reflect that the witness has identified the defendant.
Record should so reflect.
Asia, are you aware that there is a case open today involving yourself and Eric West Johnson?
Yes.
And, the case was initiated because of an incident that happened on May 8th, 2026. Do you remember that?
Yes.
And following, well, let me ask you that, on that day, did police arrive?
Yes.
And was he arrested that day? And was the defendant arrested that day?
Yes.
You gotta keep your voice up for us, okay?
Following that, were you aware of any type of order made by a court that did not allow the defendant to have contact?
We're speaking in reference to the assault,
No, following the incident in question where the defendant was arrested, were you made aware of any order that did not allow him to have contact?
the police removed him from the residence and told him to not return.
And are you aware of any order that was put into place that?
By a judge. You're shaking your head no?
No.
Are you aware of something called a no contact order?
No, there was no contact with it.
Is that to your knowledge?
Yeah.
Okay. But do you recall the police telling you not to return the?
Yes.
Your Honor, at this time, I would just like the court to take notice that there wasn't no contact.
All you have to find out, listen, did he have any contact with you on or after May the 10th of 2026, either by way of phone call, texting you, emailing you, coming to your home, coming to your place of employment or otherwise?
No, I seen him the day at the house when I came.
You know, what day was that, ma'am?
I'm having a hard time here.
Okay, listen to me. I want you to listen. Just listen to me.
So I need to be able to see my phone to understand which one we're talking about.
Okay.
Over that entire week, the police had been to our home like 5-6 times.
And if I may approach.
Yes, the incident occurred on May 8th, right?
With the knife, or are we speaking?
The case that we're here on today, ma'am, look at me, please, just look at me. The case that we're here on evolves from a May 8th incident of 2026. You're aware of that?
Yes.
Where he's charged with felonious assault and domestic.
Yes.
He was arraigned on the charge on May the 10th of 2026 by a judge out county.
Okay.
The judge laid out conditions like you can't have contact. Wait, just listen. You can't have contact. You can't go to her house. You can't go to the Matt's Drive house. So I want to just talk about anything that happened on or after the date of that order of May the 10th.
Okay.
Did he have any contact with you on May the 10th in the evening or thereafter up until today's date of May the 26th?
Yes, when I went to the residence before. When I went to the residence before the court date we had before this, he was at the residence.
What day was that? You can look at your text. You need to look at your phone to refresh your recollection?
Yes.
Okay, go ahead and look at your phone.
It was May 15th.
Okay, what happened on May 15th?
May 15th around 2 o'clock, 2 a.m. Yeah, I went to the residence to retrieve the things that I packed and left by the door. When I left on Mother's Day when my father passed away. When I got to the house, I opened the door and I had came in. Prior to this, Eric had took all the doorknobs and the locks. He took all the doorknobs off all the doors except for one. He took the locks off the doors.
So you appeared there at 2 a.m. to retrieve personal
Yeah.
property?
Into.
Wait a minute, listen to me, listen. On May the 15th, you returned there at 2 a.m. to retrieve personal property.
Yes.
And he was in the residence.
Yes.
And there was an order for the record from Judge, it looks like, or Magistrate Boyer, I don't know what court he's out of, but at any rate, it was signed May the 10th. Do not enter the following described premises, 23652 Mats Drive, Brownstown, and do not have any contact with AJ Calvin. Why were you returning there at 2 a.m. though?
Because prior to this, like the reason why I was living with him is because I told him my car almost died. I don't have a vehicle. So I have to go by, whoever that's around me who has a vehicle that's able to take.
Did he have any other contact with you after May the 10th up to today's date, other than on May the 15th?
No.
Your Honor, if I may, continue. Did he, text you at all prior or after that day?
After what day?
After May 15th?
He texted me on May 15th.
What does the text say?
He sent me $103 and said, "This is all I have. My Uber account is gone."
And for the record, this text screenshot was shared with defense.
This text happened while I was in the house.
And, so following that day, did you leave that home was it in Brownstown Township?
Yeah.
And
Can I ask a question? I don't want to take the wind out of your sails here. Did anything else occur? Any other texts? Any other time he called you, saw you, emailed you, phoned you, whatever you want to call it, or came to your house, or came to your work, or came anyplace else after May the 10th, other than the contact you had on the 15th and the text message that you just described that he sent you?
Eric called CPS on me.
All right, well, that's a different issue. Did he?
He hasn't had direct contact with me, but he called CPS on me. And then after that, the police had showed up to my house with disturbing calls about my son. Which was also there in the report. I had lied to Eric and told him that my son was in truancy. My son is a pre-K student. He's part of GSRB.
Any other contact you had with him?
He told them that my son was in truancy, not going to school, that I was doing drugs with him.
Okay, I get it, but he made a complaint with CPS, right?
Yeah.
He didn't say this directly to you, any of this, right?
No.
Okay, I don't consider that to be a bond violation.
that is considered indirect contact and is a form of intimidation and harassment. And Your Honor, for the record, her testimony is completed if I could. Would you still like to have her testify or invite me to an argument?
Well, I think the defense gets an opportunity to cross her. You
So
wanna,
they're not, I apologize for interrupting.
it's okay.
I'm just going to ask a couple more questions. Your Honor.
Take your time.
Currently, what city are you living in?
That's stay Lansing.
To your knowledge, are you aware of if the defendant knows where you live?
Yes.
How?
He took my lease.
When you
And
say lease, what do you mean?
so when I smacked that pole and totaled my car, Eric came and got me from the hospital. And I signed my lease. After that, he took me to sign my lease. My
Let me stop
contract is
there.
huge.
Do you mean a leasing agreement?
Yeah,
Okay, so to your knowledge, did he ever have possession of that? To your knowledge?
Yeah, he told me that he took it.
And, did you receive a visit from CPS following May 15th?
Yes, after the court date, a few days after that, CPS showed up at my,
Did you ever have any type of police contact at this point as well?
no. Oh, yeah.
Did the
Yeah.
police arrive to your house?
They came to my house like 3 or 4 times that evening after CPS showed up with disturbing allegations.
Now, to your knowledge, if you recall, do you know why the police showed up?
The police told me that there was disturbing allegations that I was consuming marijuana with my son.
And, currently, is that an issue for your leasing agreement, if you're aware?
So, yeah, before I moved into this leasing, the place that I moved into, they were under other management. They've had instances where someone's team,
Who's on the lease?
I just,
So is it?
Wait a minute, wait. I think I heard something differently last week, did I not? Who is on, were you leasing this with this gentleman, this property?
no, I was living there with him.
Your Honor.
Wait a minute.
I think there's some confusion.
Yeah, there's a lot of confusion.
So there's the home in question that they were initially both living in, and she has now moved out. And she's in a home in Lansing.
Okay,
And so the lease agreement that she's speaking about is for this new home in Lansing.
okay, why are we talking about the new home in Lansing and our lease agreement?
Your Honor, because of the indirect contact that was made by the police and CPS.
Okay, but he made an allegation with CPS, right?
To our knowledge.
Now, I don't know that this, now, he might have other issues, but I don't know that that's gonna amount to a violation of the no contact. Is the CPS investigation closed?
No. it's
Well,
very-
wait a minute, wait. I don't want us to talk about the CPS investigation. I don't, under no circumstance would I suggest or order somebody not to make a complaint with CPS if valid. And the investigation is still ongoing, but here's the simple fact. He violated the no contact provision by going back there on May the 15th when magistrate or Judge Boyer told him not to. And he violated the no contact provision by texting this young lady on the date that she indicated. We don't need to talk about CPS.
I have no further questions.
Do you have questions of her?
Yes, please. When the May 15th, and you received a text from, Mr. Rich Johnson, did you contact him previous to that?
Did I call Eric prior to that?
Yes.
No, I think I called him after.
And often? Your Honor, if I showed you something, would it refresh your memory?
What is that?
This is a message.
Text message?
Yeah, it's a phone call.
Okay, you can approach and show. Okay.
Thank you. This is refresh your memory?
Take a look at that real carefully.
That's my number. So the call happened before that, I guess. Oh, no, I think that's the 15th. That might be the day.
And this is your telephone number? Yes.
Yeah,
Okay, and this is dated on May 15th?
yes.
And the time says 7:46 PM?
Yes.
Okay.
What time did he text you? Before or after that?
That was I called them, so it was the same day after that I called him.
And he already texted you before you called him.
Yeah, he texted me while I was there at the house.
And then you called him after that.
Yes.
Good, go ahead.
You're saying he texted you before he made his phone call?
Oh,
Okay. And the text that you were talking, the only text you received earlier was the one from him sending you money, correct?
yes.
Okay. And when you called him, did you ask him for money?
Yes.
Okay. Now, the lease that you're talking about is in Lansing. How long have you lived in Lansing?
I lived in Lansing for the past, I think, 3 years.
So, and your lease was on May 8th of 2026. Your name's still on a lease in Lansing. Right?
I think it was before that. I after the when I totaled my car, he picked me up from the hospital, he took me to sign my lease. And then the lease was in the car and I didn't see it again after that.
But on May 8th of 2026, you had your own residence, correct?
Yes.
In Lansing.
Yes.
And
Had you ever lived with him or you just had a dating
I
relationship?
we were living together after I totaled my vehicle.
And when did you total your vehicle?
I totaled my vehicle on.
Just roughly what month, man?
I'm sorry, a lot has happened since then.
Was it more than 2 months ago that you totaled your
Yeah,
car?
it's been like
Then we don't need to talk about it. If you were living with him,
March 22nd.
okay, all right. And you were living with him until then?
Yeah,
Until March 22nd of this,
oh no, March 22nd, I started like living with.
but you still had your place in Lansing?
No. I signed my lease March
All right,
20. I was released from the hospital and he took me to sign my lease. I was staying in a hotel prior to that, and then I hit that pole. I was coming out there to see him, and I had hit the pole, and he had came and got me, and we were staying with each other ever since.
okay, good.
And Ms. Calvin, your name is not on the lease, at the residence that in question on this case, correct?
No, it's not.
On Matt's Drive, your name's not on the lease, correct?
And you actually, when they arrested, Mr. Lloyd Johnson, you actually received a ticket that day, is that correct?
No, I didn't.
The police didn't talk to you about a ticket?
They didn't give me a ticket because Eric. So,
No, yes or no, did they give you a ticket for?
Your Honor, I'm
No.
gonna object to this question. I don't think it's relevant when she received a ticket for this, car accident.
Yeah, it's not.
It's not.
I'll sustain
they were trespassing. I was trespassed from the residence when they arrested me.
Okay, okay. I don't think we need to hear any more. I get what she just said.
Right, and I'm gonna go back to one more question. You said that on May 15th, you received a text message from Mr. Woods Johnson. Before the one that you received later in the evening, correct? Because you called him and asked him for money?
No, so when I went into the residence and he was in there, sleep on the couch and all of my things were gone. I said, where are my things? He said that all of my things were gone.
With Ms. Calvin. Do you have a text message from May 15th before 7:46 p.m. from? No. Thank you. No further questions.
So you said before that you called him after he texted you, correct?
Yeah, that call that he has was after he texted me.
And it seems like it just contradicted your testimony. What time is that? 7:40?
7:46, Your Honor.
The text messages that he sent me, the money happened at 2 a.m. That happened at 7 in the evening that same day.
I see. Okay.
And I was, just to clarify, you do not have a text message before 7:46 p.m. on May 15th.
I do the morning text message when he sent me the money.
On the 15th. That's it.
On the 8th. That's what I, and then I made that call around 7 o'clock that same day,
It's in the evening.
evening,
So that was like
hours later.
12, 17 hours later, right?
No, 2, because it happened, I seen him at the house at 2 a.m. and then I called him in the evening time at 7. Because, when I was in the home and I asked him where my things were and didn't get rid of my things, he told me that he went through them and took the things that he wanted to his mother's house and he got rid of all the other things. I called him at 7.
Okay, wait, there's no questions though right now. Just wait 1 second.
Is one minute. When you were living with Mr. Woods Johnson, it was his residence, correct? Were you contributing to that residence?
Wait a minute, wait, you gotta answer out loud. When you were living with him, it was his residence, right? And were you contributing to financially toward food or anything else? You were?
Yes. Were you working at the time?
No,
So when you called at 7:46 on May 15th, 2026, did you ask Mr. Johnson for money?
yeah, I asked him to
Okay,
return
thank
money.
you. Thank you.
Any redirect?
The last thing was that you asked him, that he asked him to return the money. What do you mean by that?
So basically, Eric. So when me and Eric were getting into it, a police officer, the day that he punched me, told him that he could, because we lived there together, because I had established residency, that he could destroy my things. He can take my things and do what he wanted with my things, and there was nothing that I can do about it. That it was a quote unquote civil matter.
Let me stop you there. You said return the money. What did you mean by that?
He took my lease, and my son's money was in that envelope. It was in the manila envelope with my lease.
And so, I had asked about,
Your Honor,
What?
objection. She's talking about things that are irrelevant to this case.
Yeah, why are we talking?
Your Honor, she had said the reason why she asked for money would be that phone call.
Uh,
I can move on.
You think?
And so you indicated you were living at the, Matt's Drive residence. Is that correct?
Yes.
And did you start living there somewhere around between March 22nd and March 26th?
Yeah.
And, did you sleep there?
Yes.
Like almost at least every night following that day?
Yes.
And did you have clothing there?
Yes.
Did you and your son live there together with the defendant? And did you indicate that you moved out sometime around Mother's Day in May of 2026?
I didn't move out. I packed all of my things and put them by the door because I was under the impression that he was not allowed to return to the house but one time with the police escort. So when I packed my things and put them down by the door, I didn't think the police were going to allow him to take them when he returned. I didn't know he was just going to come back when he was released.
I have no further questions, Robert.
Anything else?
I do have one.
Just,
Business defense concern. Excuse me 1 second. He was the friend to be with you. One question, there's not a date on here. Did you talked about a black eye, correct?
Yeah.
And did you make a report to the Brownstown Police Station with that?
Yes.
Your Honor, I would ask that, there's information here I would like to call Detective Ricard.
for what?
Because at that time, I think that
Oh, is this germane to the bond violation?
you deperjured yourself on the air. The Detective Ricard said that Mr. Rich Johnson was the complainant on the case. When she told him she had a black eye, and she went ahead and he pulled the file, and she was the defendant on the case.
Your Honor, I'm going to object to this line of questioning just on the basis that it's not relevant. It's about fire report, and this is only a bond violation hearing.
Why are we talking about that? This relates to a bond violation that occurred on or after May the 10th.
But she did state on the record, it was brought up by the complainant herself, and which is the next two on here was broken with her character.
Relevancy?
Ma'am, this is not for you to decide. I guess I'm not understanding. Can you enlighten me?
it's to her,
Well, I know, but
the truth of her testimony, on that part, where there's a discrepancy in the truth of her testimony.
because you're saying that Detective Attard will corroborate your client's version and that she was not hurt?
That's what, stated in the prior report, so I would have to go and read into that. But she, the complainant herself is the one that said that Mr. Woods Johnson punched her in the eye. I would like that either stricken because there's no evidence of that.
I have audio.
Wait a minute. Wait, whoa, whoa. You can't respond. This, no, I'm sorry. You just can't respond yet. You want to bring in Attard to contradict her testimony, correct?
Object. She's discussing a prior report. I would argue that whatever the.
I don't need to hear anything on that. I'm gonna overrule your request. And that's it. Thank you. All right. Do you have any, you can step down, ma'am. Do you have any other witnesses? Do you have any witnesses?
Do I need, I'm not gonna ask a question? Am I gonna ask a question or answer a question? Like, say.
Is he going to be called as a witness, or do you want to just rely on the testimony so far?
Yeah, I don't have anything to say on
But
that.
ask Mr. Woods Johnson, time you have already to, in this case, would you like to do that or would you like to remain silent?
All right, look, if you want to argue, make it quick.
Your Honor, the complaint indicated not only the, not the word over the no contact order, she indicated that she did see him at the household on May 15th, and she had gone there to photograph her belongings. And she also indicated that she received text messages from him. In addition.
She got one text message that
Your Honor,
where he loaned her money, right?
in addition to that, Your Honor, I think it's really important for the court to take notice of the CPS allegations and the police contact she has had with him. I understand that you did not believe that to be contact, but the people would argue that that is indirect contact. It is a form of intimidation and a form of harassment. He did that following last.
How do I make the determination that that was a form of harassment when they haven't even concluded their investigation? There's nothing in a no contact order where a judge can preclude somebody from filing a CPS complaint. Now, he may have other issues of that down the road, and it may turn out to be false. And then that's going to hurt him immensely. But I'm not going to rely on that. Here's the bottom line. He violated the no contact. He violated the judge's order. The judge told him, or the magistrate, Boyer, whoever that is, told him on May the 10th, you're not going back to Matt's Drive. For whatever reason, he chose to ignore the judge's order. That's a problem. That's a big problem. And then I don't care what kind of help you intended to give the victim. When a judge says no contact, they're not kidding. He means no contact. And you had contact with him. It's not a violation of the no contact provision for the victim to have contact with the defendant, but it is for the defendant to have contact with the victim, at least as this order was framed by the judge. Where does your client work?
You work for Amazon, it's considered your Amazon, you work full time, prior to season is coming up, working additional hours.
You can't do this. I'll let you guys address bond. What are you asking for?
Your Honor, because of that bond be removed.
No, I would ask for the person bond to continue. There has been no further contact. When this court appeared on the 19th of May, this court made it very clear not to have any contact. After May 15th, my client lost the telephone number, so he wouldn't answer the phone or have no contact. He was lost his home, moved out at this time.
You can see that on the 19th, I say that he may return to the property at 23652 Mance Drive.
He did.
And I said after 6:30.
And there was no issue.
I know, but here's the problem. I may or may not agree with that judge's order when somebody owns or is the leaseholder of a property and the other side is not. The problem is he violated the judge's order. You don't get to violate judge's orders. I'm revoking the release, forfeiting the bond. I'm going to set a reasonable bond that I think you should be able to post. But I'm telling you, 10,000, 10% is the bond. I'm revoking the release and forfeiting the personal bond. And I'm going to give you an earlier court date now that I earlier expressed, because if you can't post, you're entitled to be arraigned on the charges in the complaint within 1 week. So I'm making it June the 2nd at 9. Again, bond is in the amount of 10,000, 10%. They'll let you make calls if you don't have the money to post it, but you're not going to violate a judge's order. Do we understand
Yes,
one
Your Honor.
another?
Yes, Your Honor.
Good. Don't do it again. Do you have $1,000 to post?
$1,000 today, I can make some phone calls.
They'll let you make phone calls back there, but you're in custody until you can post it. Do not do that. You got me?
Yes, Your Honor.
All right, good luck. Have a seat there. I'm so sorry, Detective, wherever you are. This is Tyler Joseph Bensick, 26W71100. Your name, Detective?
Yeah, Detective Sergeant Vesper at the Woodhaven Police Department.
Raise your right hand. You solemnly swear affirm the penalties of perjury, the testimony you've given these proceedings will be the whole truth, so help you God.
I do.
Okay, go ahead.
Yeah, on April 1st, 2026, at approximately 15:55 hours, Officer Probst took a walk-in larceny complaint. Officer Probst spoke with victim Tammy Bensick in the department interview room. Tammy advised her wedding ring is missing and believes her son, Tyler Bensick, stole it.
I'm
Tammy
having a
states that
little
she-
hard time, Detective. I don't know if you got to speak directly into the mic or to the
Yeah,
device,
can you hear
but
me better now if I speak up?
yeah, just keep your voice up more.
Okay, Tammy states that she saw her ring on March 30th, 2026 in her nightstand at her residence, which is at 22407 Huntington Court, Woodhaven, Michigan, 48183. The following night on March 31st, she observed the ring to be gone. She stated the drawer looked like it was also gone through because everything was moved around in it. On April 2nd, 2026, I reviewed the case. Victim Tammy Bensick states that her ring was stolen and she believes that her son, Tyler Bensick, committed the theft. Tammy suspected that Tyler sold the ring to a pawn shop. At the time of the call, Tammy was unable to provide any evidence that Tyler was the one who stole the ring. On April 8th, 2026, I spoke with Tammy again via phone call. Tammy informed me that she had spoken with the owner of Flat Rock Exchange, which is a pawn shop. She spoke with worker Joseph Comig. Joseph informed her that Tyler Bensick had pawned 2 of her rings and provided her with the receipts. Receipts showed that Tyler sold 1 ring on March 30th, 2026, which was a 14 karat, 2.7 gram opal gold ring for the amount of $120. Tyler sold an additional ring on March 31st, 2026, which was a 7.3 gram, 14K white gold diamond ring for the amount of $450. Tammy states that both of these rings are hers and she never gave anyone permission to take any of them or sell them. Furthermore, Tammy informed me that she wished to pursue charges against Tyler. On April 8th, 2026, I made contact with Flat Rock Exchange owner Joseph. Joseph confirmed that Tyler Bensick did sell both of the rings to the pawn shop. Joseph provided receipts from the transaction. It should be noted that Tammy recovered her stolen rings from the pawn shop, but had to pay a total of $570 to get them back.
Based on your sworn testimony, I find that the crimes larceny in the building and larceny 200 or more, but less than 1,000 were committed. There's probable cause to believe the crimes were committed by the defendant. I'm going to authorize the issuance of the complaint and warrant. Sorry to keep you waiting. I really am. We did not know we were going into that lengthy of a hearing, so my apologies. You're all
That's
set.
okay.
Have a
Thank
good
you, Ron.
day. Thank you.
You too.
Call in the prosecutor, please. Pick people against Victor Matevsky. 26M680576.
Prosecutor.
I need the prosecutor in here, please. Mr. Kazmarek. Thank you.
Yes.
Mr. Kazmarek, your name?
Jason Kazmarek on behalf of Mr. Matesky.
We're going to formal hearing on this.
That's my client. We were just talking again. He was going to join and maybe go to the hearing by himself, not have me on it, which
Well, where is he? Is he here?
he's joining right now. He was calling in. He should be. He said he was in a waiting room. I don't know if he's in a waiting room.
Is he out there, Lisa?
I had someone by phone,
By phone. He's just phone
but
only.
they've disconnected.
Oh crap. He said all he could hear was I told him to reconnect because he said all I can hear is music. I said, you can't hear the judge. He said no. So he's calling. I told him to call again.
Tell him to call back in. I'm going on to another case
That's
here.
fine.
Will you, please?
That's fine.
Judge, can we
Counsel,
see who's in the jail real quick?
what's your name in the jail there, sir?
Bashoud
I
Hussein.
can't hear you.
Can you hear me, Hussein? The last name Hussein?
Hussein?
Is first name Mashoud?
Yeah.
Okay,
correct.
got it. Thank you.
Okay, where's Joanna Webster? Or Giovanni Webster? I can't do this, counsel. This is 26 D8279974. Where is Giovanni? Oh, you got to take your head off, Mr. Webster, and tell me your name.
Yes. Joe
I didn't hear a word you
Webster.
say it again, if you would, please.
Joe Bonnie.
Okay,
Sorry.
okay, that's okay. I'm sorry. Your name. Okay. So you said defendant has fishing license.
Yes, Your Honor.
Defendant to pay conservation fee of $10. I can't do that. I mean, if you want to dismiss, that's fine, but I can't order costs if somebody's not found guilty of something.
I understand, Your Honor. And at this point, I would just be discussing that interest of justice and there is a second, Your Honor.
No, would you just change that on both of these, please? Sadie, hand her that, please.
So, would you like me to?
You could just cross it out and initial it and do the same thing on the other one, on Koreshi. Here you go, Sadie. All right, Mr. Webster, today's good news for you, okay? They can't even, did you have your fishing license then?
No, sir. I was.
You can't fish without a license, right?
Yes.
So she's being awful kind with you. I'm gonna go ahead on her motion and dismiss the case. There's not gonna be a $10 conservation fee either, so you're all set. Case dismissed.
Thank you,
No
sir.
cost, no cost. Okay, good luck. Thank you. All right, now I have Saev Qureshi. Is he here? This is 268-27912. Qureshi, your name, sir?
Saif Qureshi.
All right, so they can't do this. I'm dismissing this case on motion of the prosecutor. They can't charge a $10 conservation fee, so I'm gonna go ahead and dismiss it. There's no costs, no fees. You are all set. Next time, don't fish without a license, okay? I know you got one now, but that's whatever. Good luck.
Okay,
Matevsky.
thank you.
Victor Matevsky, 26M680576. Where's Mr. Matevsky? You have to start your video and state your name, sir.
I think he's phone only, Judge, because he pulled over in a truck.
Okay. Mr. Matevsky, where are you, sir?
It looks like he's logged in on a device now. I just can't get him to start his video.
You got to start your video, Mr. Matevsky. Come on. We got a lot of
Judge,
people in here
I
now.
think he called in. I don't think he has a video capability. He's the phone.
Can you hear what I'm saying, Mr. Matevsky? How am I supposed to communicate with people?
Now he's
with that?
coming in on another device. Let me try that one.
Mr. Patevsky, can you hear us?
Yes, I can hear you now.
Your name?
Victor Mitevsky.
Ah, you're pulled over, right?
Yes, sir.
This is a operating while texting, prohibited holding or using a mobile device while operating a commercial vehicle. did they offer you anything, Mr. Kaczmarek?
No, Judge. It was no offer.
No.
Just plea or formal hearing.
Okay, are you guys? Is that what
Judge, I
you
think-
want? Is that what you want as a formal hearing? I'm asking you guys, Mr. Matevsky, do you want a formal hearing?
Yes, sir.
Okay. Okay, you realize you're not gonna do this in your truck. You're coming here, right?
Of course.
Okay.
Judge,
Good enough.
at this point, though, he does want me to withdraw. I would do it verbal motion withdraw. He wants to attend the formal hearing on his own without attorney. To save
Is
some
that
cost.
true?
Yes, sir.
You wish to
Yes,
fire
Your Honor.
Mr. Kaczmarek?
And to show up to present myself.
I understand, but I just want to make sure I understand. You wish to terminate Mr. Kaczmarek.
Yes, Your Honor.
And has there been a breakdown in the attorney-client relationship, do you feel, Mr. Kaczmarek?
Yes, Judge.
I'll just make a note. Would you please send me an order allowing withdrawal
I will do that.
as this attorney of record, please? Will you do that today?
I will get it done. Yes.
All right. I'll just make a note of that. Order allowing withdrawal. Now, when do you want to do this? Can we do this in a week, Lisa, or wait a minute?
June 9th at 9:15.
June the 9th at 9:15. Okay, Mr. Matevsky?
Yes, Your Honor.
So you're gonna be here in person. You understand that, right?
Yes, clearly.
All right, you're all set. Thanks, Mr. Kaczmarek. Nice to
All right,
see you.
thank you.
Take care, gentlemen.
You too. Take care.
People against Alexander Wilkins Alexander the
Thank
third.
you.
26M665-269 A and B.
Good morning, Judge and staff. John Roxanne, appearing on behalf of Wilkins Alexander. So my left, please identify yourself, sir. Judge, there's one little hoop that this gentleman's got to go through, and that's his road test because he can license for someone. Presented evidence that he's brought, the snuff on everything else, sir. I can't even communicate with my judge.
Who's out there?
It was
Okay,
the jail. I muted them.
I see. All right. He was arraigned March 31, April 31.
We're seeking a 2-week adjournment, Judge.
I'm not gonna give you another one though, okay? I think I told you that last time, but I'll do it one more time. But if it doesn't resolve by the next date, we're gonna have to set a jury trial date. I almost feel like we should do it now.
Judge, there's not gonna have to be a jury or bench trial.
All right, I'm gonna do it June the 9th on this one too, Lisa. We'll do this at 8:30. Is that good?
That's good. Thank you, Judge.
So, sir, June the 9th at 8:30. So get your work done so we don't have to adjourn it again. I can't keep adjourning this, okay? All right, you can go down the hall, get your paper notice, and you're all set. Good luck to you, sir. Thank you. Mr. Mahana, good morning. Did you already meet with the prosecutor?
Good morning, Judge. Yeah, I've spoken to the prosecutor. We have an exam that was set at 10. I'm still stuck at the Criminal Justice Center. It's my understanding that they don't have a witness.
Well, let me call him in. What are you doing on yours?
Holding.
All right. Tell her to come in with Mr. Mahana's, will you? I mean, you gotta be here in person for exams, though. I hope you're not gonna make a habit of this.
Judge, I'm not. As I told you, I am stuck
I
at
know,
the.
but I'm just telling you, you were supposed to be here at 10, were you, or not?
I was, Judge.
I'm just telling you,
Unfortunately,
you can't be calling in at 11 o'clock for a 10 o'clock exam when you're supposed to be here in person. I don't need to fight with you, but
I hear
I'm
you.
not gonna have that happen here, okay?
okay, Judge.
Let me get her in here, and if that's the case, and she's gonna nolly pros or what have you,
Who do you need, Nora?
I don't know. Is it Ms.
Nora.
Esmaro or
No, Nora.
Nora Alloway?
And my client should be. I think
Where
he's
is your
in the
client?
He's at the courthouse.
Right here, Your Honor.
Okay.
The judge needs you in there. There you go. One second.
All right. Matthew Leone. Matthew Blake Leone, 26G710217. All right, sir, come on up here, state your name.
Matthew Blake Leone. And Don Graziani on behalf of Mr. Leone.
We're gonna just adjourn this another time.
That's correct, Judge. We're close to our.
Good enough. June the 9th at 8:30. How's that? Is
Thank
that
you, Judge.
okay? Thank you. Mr. Mahana's file, counsel, where is it?
I'm sorry?
I don't know who he's got again, who this,
Dalton Parrott.
Yeah, that's scheduled for examination.
he's saying that your witness didn't show up or something. So what are you gonna do with that?
You're on the not proceed. I'm going to do this
Hand that one up and I'll take care of it.
here.
People against, what'd you write on here? People, that's all right. Dalton James Parrott, 26T710092. Everybody's name.
Good morning, Your Honor. People, PA 6528.
Good morning, Your Honor. I'm sorry.
Good, good.
Good morning, Your Honor. Najad Mihan appearing on behalf of Mr. Dalton Parrott, P59371.
Your name.
Dalton James Parrott, Your Honor.
So what is the status here?
Your Honor, the complaint inside here, we did set out subpoenas, myself and the officer in charge. Our office is on contact. We did complain
Can you write that on this stipulation, please?
No, at this time we cannot proceed. I didn't write anything. I was withdrawing.
I understand. So you sent out subpoenas, you're talking about the victim is Merrill?
Correct, Your Honor.
She did not appear, she's not cooperating, correct?
To my knowledge, we have not had any contact.
Okay, so you're gonna write all that on the stip form. And then the defense moves to dismiss.
Yes, please.
What started as a routine court hearing quickly turned into a tense showdown over a defendant accused of violating a judge's direct order. The case centered on a man facing serious charges, including felonious assault, who had been ordered to have absolutely no contact with the alleged victim and stay away from a specific residence. But prosecutors argued that he ignored those conditions, returning to the property and even sending text messages after the order was issued. As testimony unfolded, the judge carefully reviewed the evidence, separating emotional accusations from the actual facts. While claims involving CPS reports and indirect harassment were debated, the judge focused on what mattered most: the clear no-contact order. In a powerful moment, the judge reminded everyone that court orders are not suggestions. They must be obeyed. Concluding that the defendant had violated the conditions of his release, the judge revoked his bond, set a new $10,000 bond at 10%, and made it clear that ignoring a judge's order carries serious consequences.